Are you looking for a church home? We may be able to help. Major Mike Webb is not only a candidate in Virginia's 3rd House District, but also a federal whistleblower who has been identified by the U.S. Attorney General Merrick Garland as a litigation hobbyist, and he had been the childhood protege of a legendary civil rights and criminal defense attorney who had represented high-profile clients, including Hurricane Carter, Ivan Butenko, Angelo Ericetti, and Resorts Casinos in Atlantic City. And this is an important message from Major Mike Webb, who had docketed a half-dozen cases for certiorari at the Supreme Court in less than a year, bringing the first legal challenges in Virginia against the lockdowns, the mask mandates and the vaccines, expressly for persons of religious faith who are on social media. Have you, or anyone you know, had your Facebook account suspended? If so, please continue to listen. Many of those who follow abortion issues are somewhat familiar with the Freedom of Access to Clinic Entrances (FACE) Act, codified at 18 U.S.C. Section 248, that protects the access to abortion services. However, most are not aware that this same legislation contains a provision protecting the entrances to places of worship, and, since it's in 1994, although those seeking abortions have been successful 100% of the times, the provisions protecting the entrances of places of worship have rarely, if ever, been used at all, until Major Mike Webb, currently a candidate for the state legislature in Virginia's 3rd House District, in July 2021 had filed a suit against Facebook under this provision, which provides that whoever, by force or threat of force or by physical obstruction, intentionally injures, intimidates or interferes with or even attempts to injure, intimidate or interfere with any person lawfully exercising or seeking to exercise the First Amendment right of religious freedom at a place of religious worship shall be subject to the penalties and the civil remedies, to include appropriate relief, including temporary, preliminary or permanent injunctive relief and compensatory and punitive damages, as well as the cost of suit and reasonable fees for attorneys and expert witnesses. In short, if you were to bring suit and prevail, the defendant would cover the cost of your litigation. However, with respect to compensatory damages, the plaintiff may elect, at any time prior to the rendering of final judgment, to recover, in lieu of actual damages, an award of statutory damages in the amount of $5,000 per violation, and this would include both worship services and Bible study. This is what attorneys describe as a strict liability crime. If a defendant blocks your access, regardless of whether you have other options available, they are still liable. Major Mike Webb's litigation is now on its 3rd iteration, and, apparently by serendipity or Providence, attorneys for Meta Platforms Incorporated have missed an important deadline, subjecting them to a default judgment, for which in September they had retained the international law firm, Orrick, Harrington and Sutcliffe LLP, which had been founded in San Francisco in 1863. And is marketed as the second oldest Bay Area private company after Levi Strauss & Company. Orix includes 25 offices around the world, including Brussels, Düsseldorf, Geneva, Milan, Munich, Paris, Rome, Shanghai, Singapore, Taipei and Tokyo, and their practice began more than a century ago with the financing of the Golden Gate Bridge, while boasting over this time securing financing of landmark projects such as Candlestick Park, the Bay Bridge, BART and the Moscone Center, so that today they have a team of 300 lawyers based in the Bay Area alone, focusing on serving the technology and innovation, energy and infrastructure and finance sectors globally. Clearly, the investment in choice of firms suggests that Mark Zuckerberg and Meta Platforms Incorporated are taking this legal challenge seriously. And, Meta Platforms Incorporated has not spared any expense, retaining Diana Siegel-Fassenberg, a senior partner in intellectual property, a high-powered litigator who regularly represents international clients in complex litigation and brings a practical and strategic perspective to help clients achieve their legal objectives, according to her biography on the firm website. Diana, a 2005 graduate of Emory University Law School, is recognized by peers and was selected to Rising Stars for 2014 to 2015. Diana had joined Orrick's New York office in 2007 and began with the Washington office in 2010. Diana has experience in commercial disputes including high-profile Beta Company litigation. By choosing the Orrick firm and retaining Diana, clearly Meta Platforms is going all in to defend its financial interests and does not want to face the potential liability from this claim. Were you, like many, placed in Facebook jail for illegitimate reasons, such as for disseminating medical misinformation? During the pandemic, when persons of faith were encouraged to worship online, had your Facebook account been suspended or disabled, blocking access to worship online? After the termination of the pandemic emergency, did you find yourself in Facebook jail for illegitimate reasons, when you were still able to participate in worship online, including platforms like Facebook? Thank God, because you may have a claim under the FACE Act, and should consider consultation with an attorney, because you could be eligible for at least a payment of $5,000 for every religious devotional worship service and Bible study incurred during your Facebook account suspension or permanent disabling, thanks to an upcoming decision in the federal courts, if your religious liberties guaranteed under the First Amendment had been unlawfully violated. Facebook has recently taken the position that they had been coerced by the White House in their decisions to suspend and disable accounts, which only strengthens your claims against that social media platform for their decision to follow an unlawful order, and you should consult with your attorney to determine the merits of your individual circumstances. The current action to watch, now before the Federal District Court in Washington, is Web v. Meta Platforms Incorporated Civil Action 1:23 CV 00816, before Judge Dabney L. Friedrich. And, on September 11, 2023, Meta Platforms Incorporated, which had already failed to respond to an amended complaint, filed on August 4, 2023, no later than August 25, 2023, the deadline for the Privacy Act settlement opt-in period, and had still made the decision, rather than attempting to file a motion to dismiss, had submitted a motion to request additional time to respond to an amended complaint that they admitted they had not yet read, and required more time, until October 2, 2023, at which time they were certain that they had already decided to file a motion to dismiss, indicating a malicious motive. And a request for extension of time can only be granted upon presenting a justifiable reason. However, under Federal Rule of Civil Procedure 55, the plaintiff, Major Mike Webb, an unrepresented litigant, who has sought no donations from the public to finance his litigation, as many do, should have been entitled to a default judgment, which the court has been reluctant to issue for now what has exceeded over a month, tarnishing the reputation of fairness at this federal tribunal where all citizens are supposed to be entitled to equal protection of the laws and their rights to due process. But, with 2 decades of selfless service in the military, Major Mike Webb took an oath to preserve and protect the Constitution of the United States against all enemies, foreign and domestic, and that is what you should probably expect from him as your representative in Virginia's 3rd House District, but that choice is up to you. However, if you are a person with a sincerely held faith belief, and you had your Facebook account suspended or permanently disabled, Major Mike Webb has provided for you an opportunity under the FACE Act to be made whole under the law. Remember, it matters not under the FACE Act whether you had other options available, because in multiple litigations brought to defend the entrances of abortion facilities, the courts have considered this a strict liability crime.
This message was approved by Major Mike Webb, Honest.